Bill 95 by Senator Cloud. Senator Cloud, on your bill, please, ma'am.
Thank you, Mr. Chair and members. Senate Bill 95 reinforces accountability for both individuals being released under electronic monitoring and the electronic monitoring companies. As crime continues to concern families across Louisiana, this legislation ensures that electronic monitoring is not a loophole, but a tool of real consequence and oversight. It improves and strengthens the regulation, supervision, and enforcement of electronic monitoring of criminal defendants and juveniles by adding rules for service providers and penalties for violations. After visiting with the DA's Association, industry experts, and our judicial partners and law enforcement, we've landed on a number of amendments that we feel covers a few issues, clarifies the intent, and closes some problematic loopholes. So I'd like to ask to entertain the amendment set that we have here and just explain it a little bit, and then we can get into detail on the bill. I believe it's amendment set 1309.
Okay, the staff is passing that out.
It's 1109.
Oh, 1109, sorry.
Okay, let's hear what amendment set 1109 does. Please, ma'am.
Okay. I'm hoping it's in line with the same set I have here. It's just a difference of numbers. The first couple of amendments correct the statute, and then we have an amendment that summarizes additional provisions that's found in the following amendments. Yep. Did y'all do cards? Okay.
I'm sorry to interrupt you. Go ahead.
That's okay. And Amendment 6, we added an amendment to cap the penalties on monitoring companies from $1,000 per day. We added a $10,000 per individual per case cap. And then Amendment number 7, we addressed the terms of monitoring compliance, which often include inclusion and exclusion zones, usually because there are victims involved. We added some compliance protocol there. And then Amendment 8, we added some language to give deference to juveniles' cost of monitoring, allowing for the waiving of monitoring costs for juveniles under certain circumstances. Amendment number 9, we added a provision to correct an issue that the district attorneys and law enforcement had, and monitoring companies. It's to correct a provision in the bill that specifies who detains an individual temporarily for charging or repairing their devices. We specified it's actually the local law enforcement authority, so that corrected some concerns.
Okay.
And I'm almost done.
I'm sorry.
That's okay. Amendment number 10 also refers to that same amendment on detainment correction. And number 11 corrects the daily reporting that you'll find in the bill to not be compliance reports, but non-compliance reports. And amendment number 12 is a new section where we specify and define what violations or of electronic monitoring, and further defines the consequences. So that's the amendment set, and I would ask for a motion. I don't mind making it myself to adopt the amendments.
Okay, well, I'll move to adopt it. It's, do we have a question on the amendment? Okay. Senator Abraham for a question.
Yeah, just so I guess that's how it works. On your Amendment 5 and Amendment 3, what's not highlighted, that must be current law, that you're just putting that in there?
Amendment
on page 3, the wording is you insert to provide, right? It's not underlined. I didn't know whether that was just current law that you're putting in there or it's addition. And same thing on Amendment 5. One of it is just, okay, hold on.
That language gets inserted up here. It's not part of the law. It's just describing what the bill is going to do. So
Okay.
whenever it says insert in line 5 up here, it's not actually in the laws. That's why it's not included.
What about this right here?
This is existing law that remains.
It's the introductory paragraph.
Right,
To
and
make
we
us
just added some,
reproduce it,
because we're
even though
adding
it's not
additional
being
provisions to the bill.
This is
we're
being-
adding
This is new, yeah.
additional details.
All right, so what I'm understanding is that Amendment 5, that's existing law, Part A, and then it's not necessarily on Amendment 3, I believe what you told me. Okay, I was just trying to understand what was existing law and what was added on your amendment.
Thank you.
All right, thank you.
Okay, thank you, Senator Abraham. Senator Barrow for a question.
Thank you, Mr. Chairman. My question is on amendment number 6 and number 8. So you are capping the amount, so will it still be $1,000 a day, not to exceed 10,000?
Yes, yes, ma'am. Monitoring companies, if they fall in violation, the original version of the bill was $1,000 a day, like in unlimited. And we received calls from monitoring companies really that don't even do business in Louisiana, and said that would be a deterrent from them to even come and do business here because it is unlimited. And so if they had some kind of speculation on, what the cap is, we don't want to,
So in other states, do they have a cap? Because I kind of have mixed feelings about that, depending on what the violation may have been. Some companies have definitely been very negligent.
Sure, I agree with you. Yes, other states do have a cap. I received some, I can't remember the gentleman's name, but I involved him in all the conversations with the AG's office and with the governor's office. He's an industry expert, and he works with states crafting legislation, and he identified this as a problematic area, not having a cap or some, defined number for these companies. And so, that's why we put it in. Yep.
Okay. In amendment number 8, as it relates to the juveniles, can you kind of give me just a little bit more explanation on this one?
Yep, we added that provision, in the original bill, and we'll go into the original, the bill once it's amended, but we do realize that oftentimes juveniles who are ordered to electronic monitoring, they don't have the financial means to afford it, or they might be living with a grandmother or a family member, and they just don't have the means to afford it, so they wouldn't be able to participate in, being home under electronic monitoring. So we put this provision in to give the court deference under those kinds of circumstances to waive the cost of electronic monitoring on juveniles.
So this will be a case-by-case situation
Yes,
once,
ma'am.
okay,
That's
fully
right.
evaluated. Okay, got it.
Yep.
Thank you.
Okay.
Thank you, Mr. Chairman.
Thank you, Senator Barrow. The board is clear. We do have a couple of witnesses who would like to speak. We have,
I'd like to explain the bill. That was the amendment.
Okay.
Did we adopt the amendments?
no, I'm sorry. Senator Cloud moves to adopt Amendment Set 1109. I think that's the number. Is there any objection? There being none, that amendment will be adopted. So,
Well, I guess just in the matter of time, I can go to explaining the bill, if you'd like, or I can open it up to, I have two
there are
gentlemen
no
here with me.
questions. I think you've kind of explained it. Your amendment does a lot of what the
It
bill
really
does.
does, yeah.
And so we have, I don't know who wants to go first. Larry Freeman, you want to go first?
Yeah, thank you, Mr. Chairman. Larry Freeman, Chief Deputy Attorney General. The genesis of this bill, as you may be well aware of, the issues that we've seen over the last year of juveniles out on ankle monitoring. The monitor becomes uncharged, or they damage it, and then going out and committing some heinous crimes. So that kind of spurned the Attorney General to look into this a little further, and to then wanted to beef up the consequences and this particular statute to where making these folks accountable and having consequences for them not complying with the conditions of their release on a monitor. So I just wanted to let the committee know that's the genesis of the bill.
Right. The murder in front of Dickie Brennan Steakhouse kind of comes to mind.
That was one of them, yes.
In any event, Mr. Walters, you want to testify as well?
Thank you, Mr. Chairman. Christopher Walters, Deputy Executive Counsel for Governor Landry. We wanted to thank Senator Cloud for bringing this bill, and thank the Attorney General for her work and support on this important issue. And just kind of echo those thoughts from the Attorney General's office. The governor is extremely concerned about these prior instances that we've seen that have made the news with ankle monitoring where it's gone wrong. And we know that there are fixes and things that need to be done, and we think this is a good first start. Senator Cloud always does her homework, and she's always listening and working with everyone involved, and we will continue to do that as we go forward with this thing. But just something to kind of put in your mind is that electronic monitoring is a very important and powerful tool in our criminal justice system to be able to allow defendants to be able to keep going, keep a job, keep going to school, keep going to work, while they participate in this process. However, it is an important tool, but it is a privilege, and we need to make sure that we remember that it is not a right. No one has a right to be put on ankle monitoring, so we want to make sure that those individuals that are on ankle monitoring, that the process and the system is working as it should, that those violations get noticed quickly to all of the appropriate entities that need to take control of it, and that those that abuse that privilege of being placed on ankle monitoring are dealt with in the appropriate manner. So we thank y'all, and we are in favorable passage.
Okay. Senator Abraham does have some questions, I believe.
Thank you. Okay, it says that, and I guess that's normal procedure, that the cost of the monitoring is borne by the person being monitored. Is that current law, or are you changing that? It's on page 2, part B, electric monitoring program. The cost for participating in an electronic monitoring program shall be borne by the person being monitored.
Senator Abraham, some jurisdictions, some areas, they do, and that's more so on the adult side, especially in Orleans parishes, I think it's ASAP or something like that. The defendant would bear the cost as an adult. In the juvenile world, we're not so sure that is being applied. So what we wanted to do...
Didn't you say you could waive it as for juvenile?
Yeah, so what we did is, at first it said by the person, then we changed it because of a juvenile, it would be their parent. We wanted to make the parents have some skin in the game. Of course, if they can't afford it, as Senator Cloud said, the court has the right to waive that cost and absorb the cost by OJJ or the court.
Yeah. Well, I was looking on, I know this is not the, just looking on the physical note there. So the fees, it says that there's some monthly fees or whatever, that will be borne also if by that person, these fees that, what did it say here?
Yeah, go ahead.
Additionally, OJJ would be incur costs to include electronic monitoring fees to the counting area of the juvenile electronic tracking system for the development of testing and implementation. So evidently, there's some fees there, but
That would be some cost in that OJJ would incur by being the collecting agent.
if it was not a juvenile, an adult, who would pick up those fees? Does the person who has the monitor would have to pick up those fees also?
That's correct. If they're an adult, they would be assessed the fee for monitoring for pretrial, and then for post-trial if they were on probation with the Department of Public Safety and Corrections or parole, and they had a monitor. There are fees associated with that the participant is responsible for.
Yeah. Okay. Thank you. Appreciate it.
Thank you, Senator Abraham. Senator Barrow.
Quick question as it relates to children, juveniles, to be detained up to 6 hours without judicial oversight. I think I see this on page 2. Currently, OJJ protocol already allows for on-site device exchanges. Is that true?
I don't know if OJJ is here to testify to that. What we
Okay.
did, but I can testify to what the bill does. The bill, whenever someone is entering into the electronic monitoring program, they give consent for a period of detainment, and that's how the bill reads, up to 6 hours for repairs, charging if there is an issue, and it shows some issues on the monitoring tracking system, that they're able to take the individual wherever would be the designated place. Maybe it's the local law enforcement, maybe it's an OJJ intake facility, and charge the monitor or repair the monitor for them.
Okay. I'm gonna need to get further clarity. Is anybody here from OJJ? No. Okay.
What is happening now, as you probably well know, is if the monitor goes down, there's no real mechanism in place across the board that is being used to go out and pick the person up and get it fixed. The person who committed the murder that Senator Morris talked about, his monitor was dead for 30 days. And so no one went out and did anything. So what we're doing is we're trying to put some more teeth into this bill to say if it goes down, they can go out and pick them up, bring them in, and fix it immediately. So we're trying to get some immediate action by the providers as well as law enforcement on handling these cases where the monitor is either uncharged or broken or tampered with, to try to avoid some of these problems that we've been seeing.
Okay. Thank you, Mr. Chairman.
Thank you, Senator Barrow. The board is clear. We do have some more cards in support. Not wishing to speak, Jill Dennis, Association of Supervised Ankle Monitor Providers. In support, Zach Daniels, Louisiana District Attorneys Association. In support, not wishing to speak, Dwight Hudson with Right on Crime in support, and as well as Susie Library in support, none of which want to speak. In opposition, we do have Cater Hunter Lowry with Vera, Louisiana, wishing to speak in opposition. It's the only red card I see. Okay. Did we miss our red card on?
Green card, it was the first one, and it said wish.
Oh, you wish to, oh.
Yes, sir.
Oh, okay, I'm sorry, yeah, you're right, Jill Dennis, I'm sorry. You do want to speak, my apologies. Maybe that was wishful thinking. Just move along. State your name and give us your testimony, please, ma'am.
Jill Dennis, Vice President of the Association of Supervised Ankle Monitoring Providers. First, I want to say we're in full support of this bill. Thank you, Senator Cloud, and I want to thank the Attorney General's office for working so hard on this. Creating rules for the court is another thing that this bill does when an offender violates his or her conditions of release. We'll do a lot to protect our community and ensure that those that are in violation cannot continue to commit crimes and create more victims. The majority of the judges we work with daily do not allow violation reports to go unnoticed. The process is normally taken is when an offender violates a condition set by the court will contact that counsel or contact the supervision provider and ask that offender to be brought into court. If the offender fails to appear, the judge will issue a warrant. However, if the offender does appear adequately, the judge will listen to the offender and determine if the violation is excusable, meaning we need to extend the curfew conditions because they get off of work later, or they had a issue with their family that caused that violation. The judge will then talk with the offender or reset the conditions to make it to where that offender is not in violation. However, for those that blatantly disregard the judge's orders, they are remanded for a number of days and then released. This process allows the judge the ability to punish the offender, and hopefully when released, the offender will follow the rules that are set by the court. However, in some instances, our communities are forced to live in unsafe conditions due to the inaction of our judges. Like in the case of Nicholas Marana, accused of shooting 4 people, killing one of them in broad daylight in the city of New Orleans, while wearing a GPS monitor. I will tell you, because of the offender management system, crime cameras, and the work we've done with NOPD, this offender was quickly arrested. However, Mr. Marana had 41 violations after only being on ankle monitor for 60 days. The judge's failure to act allowed the opportunity for an offender already accused of negligent injuring, discharging a firearm during a violent crime, felon with a firearm, and other charges, not only to re-offend, but to take the life of 27-year-old Yasmin Webb, and forever change the lives of 3 others that were shot. The failure of the court to react to violation reports caused this tragedy. Had we already had a law like introduced here in SB 95, Ms. Webb may not have been killed, and the court would have not had 3 more violent crime victims. I think my only concern with the bill was corrected in one of the amendments where it was daily violation reports. My concern was 450 compliance reports mixed in with violation reports to a district attorney's office could cause a problem. We worked with the district attorney's offices across the state, and our standard reporting process is violation reports get sent within 24 hours, and then court reports the day before every court date is sent that list all the violations from the last court date. I did have a little bit of a concern with one of the amendments that changed the GPS provider to law enforcement agencies for the detainment. The majority of our adults that are monitored in the state of Louisiana are monitored by private providers. Changing that language to law enforcement agencies does not allow us to be able to detain an offender that needs help with their device or to charge that device. And I think we fixed that at the last session because a lot of our laws said law enforcement agencies. However, that law would mean I can't detain an offender that is failing to charge and make them charge their device. So that was my only concern. Outside of that, again, thank you, Senator Cloud, and please vote yes on this bill.
Okay, the board is clear, and we do have, now we have 4 cards in opposition, so if you all would come up at least 3 at a time. Katie Hunter-Lowry, I don't see her in the room right now. So Angel Rosenberg, if you'll come forward, as well as Terry Landry Jr. I saw Terry come in, I think. And then Daniel Genarf?
Kennedy, like Kennedy, but with a G.
Genevieve?
Yeah.
I can't identify the letters. Come on up and give us your testimony with the Louisiana Association of Criminal Defense Attorneys, I guess.
So
Yes, sir. Please state your name and give us your testimony.
Good morning. Good morning. My name is Daniel Kennedy, and I'm here on behalf of the Louisiana Criminal Association of Criminal Defense Lawyers. We also agree that that electronic monitoring needs some standards, and are grateful for the effort to do that. So we do support generally the effort. We have some concerns about the language in the bill as written. And the first concern that we have is the 6-hour detention period. I don't know if I haven't seen the most recent copy of the bill. If that's still in there, that seems to us like a long time, especially, it's cut down to 2?
Up to 6 hours.
But even allowing up to 6 hours permissively, that seems like a long time to hold a child in particular if we're talking about extending this to juveniles.
Would you rather him be in jail?
Well, I think that there could be a compromise between an up to 6-hour detention or incarceration. There could be some other compromise. Especially, I think the issue is the lack of notice. So the language goes out of its way to say you don't need to give the child notice. But I don't see why that would be necessary, where you could say you could have a letter that goes out, notice going out saying we're going to need you to come
Wait.
our
A letter, so an ankle bracelet goes out, it's not charged, and we're going to send a letter that's going to take 2 or 3 days to get to somebody?
So that's one idea, and I was thinking in that circumstance, Senator, that you would have an idea of when the charging would need to happen, because presumably it happens on a set schedule. But I think to accommodate the concern you're raising, certainly the juvenile should be required to give their electronic mail address or text, and there could be some instantaneous notice right there. But my concern is just if you have children in school and you're telling them, immediately you have to come here, miss your tests today, miss whatever you have. If the goal of the juvenile system is rehabilitation and get kids through, to complete those on time and to actually, have this be a meaningful experience to turn them around, then things like that seem like they could be worked out a little bit more precisely, is our point. And of course, up to 6 hours seems like a very long time to detain somebody. And I understand it's up to, but I don't know where that number came from. The next issue that we have is the notice of violation going to the court and the district attorney, but not to defense counsel. So I think I just heard testimony that there's a complaint that right now perhaps the reports are forwarded to defense counsel in the court. I think that might be jurisdiction specific. That's not how it works where I practice, primarily in Tangipahoa and the North Shore. But I think the opposite problem is created by this bill here, where you've excluded defense counsel and you've made it an ex parte communication, which raises its own thorny thicket of constitutional issues. So those are our two main issues, really just to tailor it to give more notice to and to comply with due process in that way. The final issue, and I'm trying to remember off my head, is the law as written says, I believe, that detention, that incarceration is mandated upon a third report, and we would urge the committee to consider amending that to a third finding of noncompliance. Again, the point of, as everyone knows, the point of the criminal legal system is to adjudicate things. And so just having a report issued that you're in noncompliance should not be enough to put you, to incarcerate you pre-trial. And, the whole purpose is to bring these to the judge's attentions, the DA's attentions, for the purpose of having a hearing to determine whether or not the person is complying with the standard, with the conditions of their release. And it wouldn't be too much, I don't think, to amend that to say a third finding, or even you could say a second finding. You could make it a little bit more lax, but to allow for that language of finding to be substituted for just the mere issuance of a report.
Okay. Senator Barrow does have a question.
Yes, I have a question and a comment. I see that Secretary Lofton has come into the room, and so at the appropriate time, Mr. Chair, I would like to ask him to come to the table so maybe he can answer the question. But you bring up a point that I'm a little concerned about as it relates that if there's a malfunction with the equipment, I think more of that burden should be on the company rather than, especially in this situation, I'm more concerned about the juveniles than the child who may actually be subject or have to be brought in, and it may be an issue that is with the equipment, and that seemingly to the author, maybe we can work on something between here and the floor next committee that it may have to go to, because that's my only concern. If it's a problem with the equipment, that should not be on the child or the juvenile.
And I think to respond to that, how you would determine whether it's a problem with the equipment or the person is to have a hearing. Mm-hmm. And that gets back to my larger point, which is that adjudication is important. It shouldn't just be that notice has been sent out and so you have to go back to jail just because you've been noticed 3 times, potentially for faulty equipment each time.
Right.
And I mean, I think that everybody concedes that happens. I've certainly represented people who, through no fault of their own, have caused a report to go off saying that they're in noncompliance, but it's just because there was a charging issue or a malfunction issue. It's really difficult to have these monitors on. I mean, I'm not saying that it's not deserved, but it's difficult to go about your daily life with an ankle monitor to shower, to sleep,
right,
to, all those things. So I think there's a lot of ways that a person could trigger a report without actually being the kind of person or the kind of violation that we want to incarcerate.
I agree with you. Thank you.
Thanks, Senator Barrow. The board is clear. We do have more witnesses who indicated they wanted to testify. Terry Landry, is he back yet? Or Angel Rosenberg, or Kim Hunter-Lowry. I assume her colleagues would have alerted them, so I'm going to go once, going twice. Okay, I guess they had other committees to go to. We also have Tia Fields with the NAACP in opposition, not wishing to speak. The board is clear. Senator Cloud, you may close on your bill. Secretary Laughlin, are you willing to come answer some questions from Senator Barrow? If you would, fill out a card when you can, a white card, I presume.
I can get in there.
Senator Barrow.
Introduce himself.
Hi, Senator.
Yeah. Hi. I just waited for you to introduce yourself. just for the record.
Kenneth Lofton, Deputy Secretary for Office of Juvenile Justice.
Okay, so my question is regarding what right now OJJ does as it relates to children who are detained for up to 6 hours without judicial oversight. It seems like you guys already have a protocol in place. It's in place as it relates to the device exchanges which have been done.
Yes, ma'am, we do. But now we're dealing with pre-adjudicated kids, youth that are already in state supervision. The way I understand the bill, and correct me if I'm wrong, this is dealing with pre-adjudicated youth.
You deal with post.
Ma'am?
You're dealing with post.
I'm dealing with post-adjudicated.
Okay,
So we're able to, we already have the court order, we're able to bring them in should they have a curfew violation or some type of electronic violation.
So in this particular bill, that would not apply.
Is that correct, Chris? If it's
That would not apply to OJJ?
Yes.
I mean, I think it would still apply. It's just that OJJ has a separate legal authority to be able to bring that child in. And I think, Senator Barrow, to your point, that this is, and really to the chairman's point, this 6-hour period is a grace period, because the only other way that the child comes in is in custody, and then you have it go before the court. This is a 6-hour period where they can come in, they can fix whatever the issue is. If they're not charging their battery or whatever the case may be, that gives them the time to charge it. If they have to switch out a monitor, it may be 15, 30 minutes to change all of that information over, because the electronic monitoring provider would have to switch which specific monitor bracelet that's on that particular juvenile in their system to make sure that that bracelet is connected to that child. So, I would say probably 15 to 30 minutes or maybe an hour if the bracelet is actually malfunctioning or something like that. That's not the fault of the child. But either way, the real issue is that when that monitor goes dead or that monitor gets cut off, somebody needs to be going. Mm-hmm. Somebody needs to be going to see what's going on.
So, and that goes back to my question as it relates to the company, because isn't there something that they receive in terms of an alert? That's my understanding. So they should be able to see when there's a problem, when there's a malfunction.
They can actually see when the battery goes dead, when it's not being
even
charged.
if it's going low, right?
Even if it's going low, yes, ma'am. And they can notify the youth. They can notify the protocol with us is they notify the youth, the parent, and then us that the youth is not charging the device. And then they're given the opportunity to charge that device. And if they don't, then we go see why they're not charging it. And they can, apparently it's, they can tell if they're charging it, not charging it, or something's wrong with the device. But we'll have to go see if they're not charging it. We'll have to go determine if something's wrong with the device is the reason why it's not charging.
I think, Senator Barrow, that's an important part of the rigor of what we're seeing as detainment of 6 hours. That's after multiple points of contact has been made with the juvenile on your device is going low, because the monitoring companies that we've worked with, they're contacting them, like Secretary Lofton said, when they're going low, or if there is an issue, they're contacting them or their guardian. And so the juvenile is made aware multiple times, and if they don't act,
that's stated here in the bill.
It isn't. It's just protocol. I mean, that's just normal protocol with the companies. I think the contractual agreements specify that.
It's just the way to do business, the way in which they do business.
And that gives me just a little pause, because, I mean, it's protocol, but it doesn't mean that it's always the standard, right?
And I wouldn't mind entertaining language between here and the floor, to make mention of the point of contact being made with the juvenile upon a low battery or mechanical issue.
Yes, I just don't want young people actually having to bear the burden of this when it may not be no fault of their own, especially with the company.
You have to be careful, Senator Barrow, because that's a kind of a slippery slope, because some youth don't want it to be charged because they want to go do what they want to do. And so you get into that tussle with the youth they're not charging it because there may not even be anything wrong with the device, but they don't want you tracking them for the weekend.
So
They let it run low so they can do whatever they want to do.
But that should be like a pattern, right? That you're able to kind of like identify if,
Sometimes. Yes, ma'am.
I
It's a
want to
challenge.
be, I think that's a challenge as it relates to, the equipment, and I want more burden to be on the company as opposed to, especially juveniles, because I think that sometimes, I'm not going to paint this with a broad brush, but certainly the companies need to own up to the responsibility or the lack thereof if they have not really properly been actually tracking these individuals.
I agree.
Yeah. Thank you, Mr. Chairman.
Thank you, Senator Barrow. Now I think the board is clear, so Senator Cloud, you may close on your bill.
The two attorneys here told me, I don't have the law in front of me, but they said it's already in the law that they have to send notice when the battery gets low. So we'll be gathering that area of law and getting it over to you, Senator Barrow. Did listen to the testimony on the findings of noncompliance or the noncompliance, three issues of noncompliance, and then they would, be remanded into custody, and where he said findings, not just basically allegations. I don't know what the right term is in the bill, but we're gonna look at that and make them actual findings, and then the notification piece, we'll take a look at that too. But in closing, since there are no other questions, I'd just like to say that this is a great bill. It holds both offenders and providers accountable, and I wanted to reiterate what you said, Mr. Chair, is that this is juveniles and adults that are on monitoring. It is grace that they're not incarcerated or serving in secure care, that they are able to be, in society and enjoying, certain freedoms. But we do have to have guardrails. And so this bill prevents the abuse of leniency, and it ensures real consequences for noncompliance of both those offenders and providers. It strikes a good balance between rehabilitation and enforcement. So with that, I'd either make a motion or ask for one.
Okay, well, I'll make the motion for you. So I move to report Senate Bill 95 with amendments. Is there any objection? There being none, that bill will be reported with amendments. Thank you all.
Thank you, Senator. Thank you, Chairman.